I'd like to welcome all of you to the 2016 Whittaker Award presentation. My name is Clay Norkey, and I am the past president of the Lawyers Association of Kansas City and the current president of the LAKC Foundation. I am pleased to welcome all of you today and offer a special welcome to our guests of honor, Mr. David Boies and Mr. Ted Olson. I am also thrilled to welcome back our 2015 Whittaker Award recipient, Judge Danelle Reese-Taha. I understand that we have some prior Whittaker Award winners with us here today, and I'd like to have them recognized today. If they could stand as I read your name. We have Bert Bates, Woody Davis, Gordon Gee, Jack Kilroy Jr., Pat McClarney, and David Oliver. Please stand so we may recognize you today. The Whittaker Award is named for Justice Charles Evans Whittaker, and we are pleased to have Justice Whittaker's son, Kent, here with us today, and his granddaughter, Kate Whittaker. Like Judge Taha, Justice Whittaker was a native Kansan. He was one of the founders of the Lawyers Association, a U.S. District Court judge, a U.S. Court of Appeals judge, and an Associate Justice of the United States Supreme Court. We established the Whittaker Award in 1976 to honor the justice. It's presented to persons who have promoted the welfare of the public and the bar, encouraged cordial relations among members of the bar, advanced the science of jurisprudence, supported the administration of justice, and aided and supported the courts in the administration of the rules governing the practice of law. Our organization strives to adhere to those principles, and we believe we have chosen two professionals who embody those today. To tell you a little more about the Lawyers Association of Kansas City, I would like to now introduce the current president of the LAKC, Brian Baggett.
When Justice Whittaker founded the association in 1935, it represented a coming together of local attorneys in town to work toward common societal goals and public interests. They came to the association with differing viewpoints on issues, different political beliefs, and in many cases came to the board as adversaries in prior matters. Yet they found a way to put those differences aside and work toward these goals. And over the years, the association has made remarkable headway on a number of issues, including attorney discipline reform in Missouri, eliminating fraud in jury selection in Missouri, anti-loan sharking legislation, and other matters. The association continues to make progress on other social issues as well. And given these values and the mission of the association, it's very fitting today to have Mr. Boies and Mr. Olson here to receive the Whittaker Award. And I think we're all thrilled and looking forward to their presentation later today. As Clay mentioned, in the years past, we've been fortunate to have a member of the Whittaker Award family here to give the perspective on Justice Whittaker. And today we have his son, Kent Whittaker. So I'd like to invite Kent up to make a few comments and give us some insight as to who Justice Whittaker was.
The comments will be few as promised because I've been doing this for over 35 years now, and I'm beginning to run out of things that are new to say. First of all, I want to thank each of you for your attendance and thereby helping to keep my father's memory alive through the granting of this annual award. He has been dead now for over 40 years, and so there are few, if any, present members of our association who knew him personally. But this award, like others of its kind, are valued not so much by the name of the person for whom it is given, as by the stature of those to whom it is given. And certainly this year's recipients add greatly to the luster that has been provided by prior awardees. As I've said, I've spoken for some 35 years or so at these luncheons. Often, generally when I am struggling to find something new to say, I wonder why we continue to do this. I've become convinced, however, that it is because this organization and lawyers in general, like most people, need to hear about our heroes. It is them and the stories about them that make us try harder and achieve more than we otherwise might. My father, as you all know, was a Kansas farm boy. He learned his first little knowledge of the law by reading articles about cases in the St. Joseph, Missouri newspapers. The local citizenry in Troy, Kansas, near where he grew up, remembered that he gave what he thought were terrific arguments while driving teams of horses and mules around my grandfather's farm. He got the money to come to Kansas City by trapping skunks, which he said was profitable but did not particularly endear him to the school. He came to Kansas City, living in the YMCA, which was then located about 1 block from where the United States Courthouse, which bears his name, now sits. He put himself through school by working as an office boy at a law firm in Kansas City. He first with that background, he became, after he joined that firm upon graduation, a founder and a president of this association, the president of the Missouri Bar Association, a judge on the United States District Court for the Western District of Missouri, and then took his seat with President Eisenhower's appointment on the Supreme Court of the United States. You can just think that with those achievements and his background, what we might all accomplish if we labored as hard and as diligently as he. I'm sure that this year's recipients and many of you have equal stories about great achievements from humble backgrounds. And I tell you, I don't think we can too often hear them because they ennoble us and they make us strive for more than what we would otherwise be. With that, I would simply like to thank our recipients for accepting the award, and it is our honor to give it to you, and I very much appreciate your attendance and the enhancement that you give to my father's reputation. Thanks very much.
It is now my honor to introduce our presenter this afternoon and the moderator for our program, Judge Danelle Reese-Taha. Judge Taha is the Dean of Pepperdine University School of Law, and when not sunning herself on the beaches of Malibu, she maintains close ties and a home here in Kansas. Judge Taha is a former Chief Judge of the United States Court of Appeals for the 10th Circuit and was the LAKC's 2015 recipient of the Whittaker Award. Last year, Judge Taha issued a calling, a challenge to lawyers to embrace the nobleness of our profession. She asked us to train up talented and just people in the practice of law. She implored us to inject more civility into the practice of law and encouraged us to promote a positive and civil discourse in our jobs, in our communities, and in our governance. We acknowledged and accepted that challenge. And we believe that we have found two individuals who have given us a shining example of bipartisanship that embody her ideas. Two people from the opposite ends of the political spectrum who have mutual respect for each other found a way to come together on one of the country's hottest and emotional debates. They found something they could agree upon, and they found common ground. They worked together. We thank Judge Taha for her motivating remarks last year, and we are thrilled to welcome her back. Ladies and gentlemen, Judge Taha.
What a privilege it is to be back with you, and last year receiving this award was one of the singular honors of my career, so thank you so much. Today is a high moment for me to have the privilege to introduce two friends who've been friends for a very long time and who do embody those ideals that I sort of implored you to pay attention to last year. The two gentlemen who are with us are giants in the legal profession. When you say big case in this nation, you hear Boies and Olson almost always related to the biggest cases. For the history of their careers is a litany of the history of modern litigation. I could go through the names of the clients they have represented, but you would know them all. They have much in common. They both hail from Illinois, and the Whittaker family will be glad to know from pretty humble origins in Illinois. They both somehow made it to California for some, at least, undergraduate work, and then Mr. Boies, David went to Yale Law School, and Ted went to Bolt Hall at Berkeley. They both have spent a great deal of time in and out of various public service positions in the United States government and for causes that they believe in. Rather than me talk too much about them, I want you to hear their stories in their own words. But what I want you to know about these two incredible lawyers who are respected the globe around is that they do hail from very different political persuasions and causes and beliefs. Ted has been pretty much identified with issues that conservatives have adopted and was one of the founders of the Federalist Society, which now is so influential in the legal profession. David, on the other hand, famously has been involved with some very, very important democratic causes. But they are lawyers. They are advocates for what they believe in. And one of the most moving opportunities I ever had was what I think you will see today, was how they came together on an issue of such enormous importance to this nation. Lawyers Association, thank you for hearing me last year, and thank you for bringing the stars of the show for civility, professionalism, and the highest standards of this profession. Welcome to the stage, David Boies and Ted Olson.
I think this is really appropriate. Ted is on the left and David is on the right. We want to leave some time for questioning, but I want you to hear their story. Now, not surprisingly, they were opposing counsel in one of the most, perhaps the most, important case of our time, Bush v. Gore. So I'd like each of you to tell this group what your journey was like to becoming co-counsels in this important series of cases. David, do you want to start?
It was relatively short. Ted called me up and said, would you like to bring a federal lawsuit to enjoin Proposition 8 as unconstitutional? And I said yes. I didn't bother to check with my partners or my wife, who fortunately ended up supportive. But it was an opportunity to work with Ted. We had become close friends. Our wives had become close friends. And we talked about doing something together. And this was an opportunity not only to work with him, but an opportunity to take on what I think both he and I believed was the most important civil rights issue of our generation. And so it was a great opportunity, and I will always be appreciative to Ted for bringing me into it.
We both grew up, in part, in California. I think we both felt the same way when the citizens of California, on the same day that the citizens elected in California Barack Obama to be President of the United States, passed a ballot proposition that prohibited marriage except between a man and a woman, taking away a right that had been granted by the California State Supreme Court only 6 months before that. I was asked to whether I would consider bringing a lawsuit to overturn under federal constitutional grounds the Proposition 8 measure. To make this somewhat concise, we felt, because of the background that I've had in conservative politics, that it would be better that it not be perceived as a political thing, and that we wanted to have the legal team consisting of people on opposite ends across the political spectrum, so that, as David and I tried to put it, this was not a Republican or Democrat or conservative or liberal issue. It was an American issue. It was a constitutional issue. And we wanted, at the same time we handled the case in court, to present to the American people the arguments why citizens of this country who fell in love with someone who happened to be of the same sex would have the same rights under the 14th Amendment to equal protection and due process that others have. When we talked about creating that kind of team, David Boies' name came up. I suggested it because we'd been on opposite sides in the Bush versus Gore case. We had become friends, as David had said, but what could be more symbolic than someone on one side and someone on the other side of that presidential election contest that went to the Supreme Court? And when my colleagues heard my suggestion, they said, do you think that could possibly happen? And of course, David just related the fact that I placed a call to him. I really didn't have any doubt about what David's reaction would be. Some of the members of our team thought, well, you were going to have to talk him into it. It was maybe 15 seconds into the call, really before I got the question out, that David said yes, committed his law firm to handle this case, and so the two firms worked together from the beginning to try to overturn Proposition 8, create again the rights of same-sex persons to get married in California, and also to try to sell the concept of equality to the American people.
Could you just sort of follow up on, at first it was Prop 8, but then you got yourselves into a lot longer line of cases than I think you probably anticipated. Did you ever consider sort of breaking up the partnership?
Not on my half. I'd been on the opposite side of Bush v. Gore, and I knew it was not a good idea to be on a different side from Ted. I think that when we went to Virginia, which is where we went afterwards, we went there for two reasons. One, This was the heart of the opposition to marriage equality in many respects. The Virginia Constitution was one of the most discriminatory constitutional provisions of any of the states. It also had a symbolic significance because it was, of course, where Loving against Virginia came out of, which was the racial marriage equality case that the Supreme Court had decided now almost 50 years ago. And we also thought that this was a case that would inevitably, we were wrong about this, but we thought inevitably would go to the Supreme Court because while we had won the California case on standing grounds, that is, the court had dismissed the opposition's effort for certiorari ultimately on the grounds that they didn't have standing, we believe that in Virginia we would have a clear degree of standing for both sides. Now, it turned out that the Supreme Court didn't take it, in that case either. But we did establish in the Fourth Circuit, as we had in the Ninth, the right of marriage equality. And then soon thereafter, of course, the Supreme Court held in a great decision that it was a national right in every circuit. But we were in it for the long haul. We said that at the beginning. We said our goal was marriage equality in 50 states and that we would keep filing lawsuits until we'd achieved that. It went faster than I think most people thought. Indeed, it went faster than I think we thought it would. But I think it was an effort that we were committed to from the beginning.
Maybe picking up on that, where do you think it goes next? And would you be willing to sort of hypothesize about the route of the litigation from here on?
Well, I'll just say this, that gay and lesbian citizens in this country have suffered an enormous history of discrimination in various different ways. During the Eisenhower administration, there was an executive order that provided that you could not hold a federal job if you were gay or suspected to be gay. And we went into the trial and proved the history of discrimination and how damaging it was to our citizens. The vestiges of that discrimination in various different parts of the country still exist. Gay and lesbian people are denied rights, they're discriminated against. You've read about the issues having to do with transgender individuals who are fighting barriers to their treatment as respected citizens in this country. We are committed whenever we can. David took a case involving a member of the Boy Scouts who was denied a relationship there, and David's been involved in various things. We come together whenever we can to bring whatever force we can. One of the things about this being on opposite ends of the political spectrum, people are still surprised that we want to work together or will work together or have a relationship of working together. One of the things that does is gives us the opportunity to talk about it. When people say, well, why did you get together with David Boies, or they ask David the same thing about me, why in the world would you be in the same room as Ted Olson? We can then explain why we feel the legal issues are important and why, and it causes people to think not so much about Ted Olson and David Boies anymore, but to think about the rights of our clients and to think about the legal principles that we're trying to advocate and trying to explain. Because if you explain these things, you can change people's minds. That's what all of us in this room believe. But you have to have the opportunity to make the explanation, to make the case. In a way, the two of us working together, it's easier for us to make the case.
I think it does another thing, and I'd like you to, there are a lot of newer lawyers in this audience, and you all have had, let's say, a long career, but you've made a lot of litigation choices. Another thing it does when you get together is educate the public about what an advocate is as opposed to an adversary. And would you reflect, for the benefit of the audience, on what you think newer lawyers should know, and how you make your litigation choices, and where you draw lines, the kinds of hard questions that present themselves?
I think one of the things I'd say to young lawyers is remember that you are part of a justice system. It is an adversarial justice system, but you are only one part of that. Your job is to advocate for your client, and the other lawyer on the other side's job is to advocate for their client. And together, with a neutral judge, we think, and I think we think generally rightly, justice will come out of that process. But your opponent, the advocate on the other side, is as much a part of the process as you are. He or she is probably as committed to their client as you are. It is a process that ennobles everybody who is participating in it. And if you have, as I saw in Ted, somebody whose ability I admired, whose integrity I was impressed with, that is a person that you're going to want to be friends with. You ought to be as friendly with the people on the other side as you are with the people on your side. This is a profession that we all spend so much time together, that if you don't like the people that you're dealing with, you're going to have a very unhappy life. When you can get together and have dinner, have drinks, go out, and enjoy the company of the people that you are in court with, sometimes on the same side, sometimes on different sides. I mean, since Bush v. Gore, Ted and I have been on the same side a number of times. We've also been on different sides. I remember one Court of Appeals argument in the Second Circuit, which I thought was going to go on forever. My only problem was that the judges kept asking him questions, and he kept giving good answers. And I think that when you're having that kind of competition, it is the highest form of what we became lawyers to do, because not only is it satisfying and exciting and challenging, but you know that you are making your contribution to the justice system, and you recognize that that contribution is coming from the person on the other side.
You can also, and you should also, learn a lot from not your enemy, but your opponent in court. David and I became fascinated with David's ability as an advocate during Bush versus Gore, because we would be in court, or we would be here and there, and then we'd be out on the sidewalk talking to the media, and that was going out all over the world, and I was watching what David was doing, and I was amazed at the ability for him to summarize an issue in a persuasive way. I almost found myself agreeing with him before I caught myself and realizing yet again that he was on the other side. But I thought, and I told the young lawyers on our team, watch him. He's really, really good. So when we had a chance to get together in the Proposition 8 case, David did a lot of the cross-examination and some of that, and I did some of the legal arguments. I mean, we tried to use one another's skill in a complementary fashion. And then after that argument in the Second Circuit, we were opponents, and it was a big deal. This was billions of dollars. And then we came out on the courthouse steps, and the reporter would ask me a couple questions. I'd ask David a couple of questions, and they didn't see what happened after that. David went to his car, I went to my car, and we got together at the Four Seasons for dinner.
In this both co-counsel and opposing counsel roles that you've played with each other, is there anything that surprised you about the other?
No, I don't think so. I think with both of us, what you see is what you get. I don't think either one of us is that complicated of a person.
Well, you know, lots of things surprised me about David, all good things. You know, I mean, I think you know David's history. David's dyslexic, and he doesn't mind having that mentioned. It's been written about before. And so there's issues with respect to reading and so forth. He can explain that better than I certainly can. But when we were in trial together, we were in 3 weeks of trial, David was reading preparing his cross-examination, I've never seen anybody prepare harder for what was going on in the court and than what David was doing to be ready, and then to watch that cross-examination. And I've told David I want either him to write a book about famous cross-examinations that he's been involved in, or I'll write the book about his famous cross-examination. I just want to learn about that because watching it is a fabulous experience. That's, I guess, my point. You can learn so much from your colleagues, whether they're on the same side of the aisle in that court or on the other side of the aisle. And David's ability continues to amaze me. He can pick up something and summarize it in such a way you almost have to agree with him, unless it's one of those cases where you don't want to at the end.
I'll just add a little postscript. I think it's true, I read that it's true that your mother read to you early and often. Your parents were both teachers, and allowed him, I think it's fair to say, to sort of take care of that dyslexia. Is that right?
Yeah, no, both of my parents were public school teachers, and they believed that I was smart, like most parents believe their children, but they also recognized that I had a lot of difficulty in reading. So they would read to me and talk to me, and that's the way I learned. I didn't read until I was well into my 3rd grade, and then I read pretty slowly. But I learned a lot because I learned to listen, and I learned to listen from my parents, and I found that you can learn an awful lot if you're just patient and you listen.
I want to turn to a slightly different topic. When you think back over your careers, over quite a few decades, and the list of your clients are the giants in industry, are some individuals. They both have a lot of sports in their background on various sides of various sports issue. I think it's true that David left Cravath over a little tiff between the Yankees and Steinbrenner. I think maybe Ted's involved in Deflategate these days. They both have a lot of sports. When you think back to the beginnings of your career, what was it you aspired to, and did you ever anticipate where you would be today?
I don't know about Ted, but I never anticipated where I would do, and the opportunities that I've had and the cases that I've had. When I was in school, I wanted either to be a high school American history teacher like my father was, or a lawyer like Perry Mason. And I was attracted to the law because of the excitement of trials, the challenge of trials, and the importance of the trial and the law as a way of advancing justice. Growing up in the late 50s and early 60s, when the cause of racial injustice was just really coming to the fore, it was an opportunity to use the law to break down barriers of discrimination, to use the law to try to begin to fulfill the promise of our founders and our founding documents. And that opportunity, I never expected to have as many of those opportunities that I've been given. But I think that was what inspired me to become a lawyer. It's what I wanted to use the law to do. My first cases were civil rights cases in the middle 60s in Mississippi. And to have the opportunity later to work in the area of marriage equality and the like was exactly the kind of thing that I would have liked to have thought I would do, but I don't think I really thought I was going to have that opportunity.
Have you got anything?
Well, you mentioned sports. I think I was attracted to the legal cases that I've had involving sports, not because I was any good at sports when I was younger. So this was an opportunity to participate in a contest. That is what the law is in many respects. It's communication. It's explaining your point. It's writing the best brief that you can or making the best argument. On the sports side of things, it is interesting. David and I found ourselves on opposite sides. David represented the National Football League, so the liberal David Boies was representing the billionaire owners against the poor laborers that I was representing at the NFL Players Association.
The multimillionaire players.
Yeah, they called it the billionaires versus the millionaires or whatever it was. We've been at this for collectively 100 years, or I think it's past that now. We said that before, and people said, well, it's not quite 100 now, it's quite a bit more, a little bit more. But the legal profession, we don't need to tell those of you in this room, is the greatest opportunity in the world to continue to learn. Each case is different, each situation is different. There's a way to do it differently. There's always a way to do it better if there's a way to learn from the younger people. We talked about the younger people before we came out into this room. You can learn a tremendous amount, and we both feel the same way, but the learning process never stops. So it's always exciting, it's always exhilarating, and it's an opportunity to learn something all of the time.
We want to leave some time for questions, but I just can't help myself. We have a Supreme Court vacancy at the moment and a presidential election looming. Would you care to hazard a guess about what's going to happen you don't have to name names, but what you think that the Supreme Court will be taking up? What are the issues, and what direction might it go? David?
Well, I won't predict what's going to happen. What I think ought to happen is I think the Senate ought to confirm Garland, and I think if they haven't done it before the election, which they are not going to do, I would hope they would take him up in a lame duck session and confirm him regardless of who wins the election. I think he is an extraordinarily qualified person, and I think nominating him was, I think, an important step, and I think confirming him would be another important step in reducing the politicization of the appointment process to the court that we have fallen into over the last several decades.
David and I agree on this, and I wrote a piece in the Wall Street Journal several months ago saying that the Republicans in the Senate should grant Merrick Garland a hearing and confirm him. He's a splendid person. He's the kind of person you want on the Supreme Court. The Republicans, to the extent that you're talking about this from a partisan standpoint, could do a great deal worse. He's a terrific, modest person. He's highly respected by the other members of the D.C. Circuit. We both hate, and I think probably most of the people, and maybe everybody in this room, hates the politicization of the process. Justice Scalia was confirmed by the Senate unanimously. So was Justice O'Connor and so forth. But in recent years, it's become, there were 20-some votes in the Senate against John Roberts. Hard to find a more qualified person. There were 40-some votes against Sam Alito. There were a lot of votes against Elena Kagan and Sandra Sotomayor. It is, and all of those people are extraordinarily well-qualified people. I have argued before them. They are really good, and I've won their vote sometimes and lost their vote sometimes, but they are the people that should be on the Supreme Court. There shouldn't be a dissenting vote for people like that to be on the Supreme Court. And the more we make it a political contest, where members of the Senate on this side or that side, both sides are guilty of this, are tearing down the person that's about to go on the Supreme Court, we're disrespecting our judiciary, which is the finest in the world, the envy of people in the world, and we're disrespecting the people that are then going to be deciding the most important cases for all of us in this country. So somehow that has to be brought to an end. I wish there could be, and we've talked about working together on this, and I don't know if they'll listen to us anymore, David, but we think that it's exceedingly important for the United States Supreme Court. Once you're appointed to the Supreme Court, all of the justices on the court were appointed in their 50s, or Justice Thomas in his 40s. Justice Ginsburg was 60, but she's the oldest one, and Merrick Garland might be an exception because he's 63. President Obama very carefully calibrated that appointment, hoping to get Republican votes. But by and large, someone appointed to the Supreme Court is expected actuarially to be on the Supreme Court for 25 years. That's 6 presidential terms. That's a long time. And we really need to have people we respect. And lawyers have the responsibility. Lawyers have the responsibility to tell the people that this is someone worthy of respect, whatever party they happen to come from, so that the American people can understand this isn't an election between partisans. It shouldn't be. We are not working on this case, a specific case directly, but one of the things David has been involved in and I've been involved in slightly different cases is education. Education for our young people in most parts of this country, especially poor people, especially people from the inner city, is abominable. People are experiencing education which prevents them ever from getting out of the cycle of poverty and poor education. We did a case in California that David helped us with called the Vergara case, in which we demonstrated that California developed a system where you got tenure even if you were a second-grade teacher after something like 15 months, and if you were a bad teacher, you couldn't be removed, so that people, and the worst teachers kept getting rotated into the inner city. And if you have a bad teacher when you're a 3rd grader or a 4th grader or something like that, it can set you back enormously. If you have a bad teacher or failing teacher 2 years in a row, that pretty much ends it in terms of your opportunity to be successful in life. David's worked on, and I'll let him speak for himself, but he's worked on cases in New York, and we've worked on other cases, and we've spoken about this and written about it, because we think one of the things that's so exceedingly important for this country and the values that we represent is to provide an education and an opportunity for young people, especially people that can't afford to go to private schools or things like that.
I think we both think that education is a basic civil right, and it is a civil right that in some ways makes every other civil right more functional. The right to vote really depends on the right to understand what's happening, which really depends on having an education. And our ability to compete in the world depends on having an educated workforce. As a matter of fundamental fairness and as a matter of self-interest, we've got to do a better job of educating the American children. And there are a lot of impediments to that. Some of them are financial. Some of them are institutional. One of the things that we're doing in New York right now is we've got a lawsuit against the teacher tenure system and the refusal of the teachers' unions to permit people to be evaluated, teachers to be evaluated. I mean, think about it. Would you pick a doctor? Would you pick a lawyer? Would you pick a plumber without an ability to evaluate, without ability to choose somebody who is doing a better job? And yet we're entrusting our children into an educational system in which, from an institutional standpoint right now, there's no choice. There's no ability to choose. There's no ability to discipline. There's no ability to hire better teachers. We had a program in New York in which private sources came forward and said, we're going to donate money to be given as bonuses to teachers who will take on the worst schools in the inner city areas, the poorest neighborhoods, the children that need the most help. We're going to give bonuses, private bonuses, to people who are willing to do that. That got stopped by the teachers union. So there are enormous barriers that have grown up over the years that we have to address. I think the courts are, again, one way of doing that. Legislatures are important, but sometimes legislatures are frozen for a whole set of political reasons. And then it's up to the courts and it's up to the lawyers to make the promise of equality that's in our Constitution, in all our founding documents, a reality. And I think education is an area where we have an enormous way to go.
I can't help myself. For the Kansans in the audience, the last two topics are very high on our minds at the moment. I want to also point out about these two people that they do so much work that there isn't a billable hour for, and you've just heard some examples of that. Sort of as a parting gift, well, I'm just going to say, they both funded things in education, been involved in the American Constitutional Center, founded the Federalist Society. They have done all kinds of things that I suspect the timesheets made no difference whatsoever. As a sort of a parting bit of advice to everybody, what do you think about your involvement in non-billable hours, pro bono work, and what responsibilities do we have?
I think it's a responsibility. I think it's an opportunity. You were talking about the young lawyers a moment ago. And the thing I would say to young lawyers is don't forget why you went to law school. We didn't go to law school. Very few of us went to law school because we thought it was a great way to make money.
You've managed to do that.
That's true. And I know it does offer an opportunity to do very, very well financially. But I think that there are other ways to do well financially, and maybe easier ways. But even for people who see the law as an economic opportunity, I think people choose the law because they believe in the justice system, because they believe in the role of the courts and lawyers can have in making this a better society and protecting people's rights and helping people. And it's easy when you get out of law school and you start working and you've got the demands of a job. Maybe you get married, maybe you have a family, you're now worrying about paying for a house and paying for student loans, maybe a car, maybe saving for the education of your children. And you can lose sight of the fact of what made you become a lawyer in the first place. And the need for pro bono work, broadly speaking, the need to be of service to the community, to service to the profession, service to clients who can't afford your charges, which are almost everybody as far as my law firm is concerned nowadays, and an opportunity to advance major causes like marriage equality or education or whatever your passion is. Spend the time to do that. I think you'll find it enormously rewarding. And there's still going to be plenty of time to earn a decent living. One of the great things about this profession is that we are paid very well to do something that I hope most of you enjoy as much as Ted and I do. And there's an opportunity in the pro bono area to give back. But it's not just giving back, it's also getting back. Because I think if you were to ask Ted and myself some years from now, looking back over our entire career, what was the most memorable things that we did? What was the things that gave us the most satisfaction, that we're proudest of, that we're happiest that we did? It's not going to be how much money we made. It's going to be cases like the marriage equality case. It's going to be cases that we were in not for the billable hours, but for the goal of achieving justice in the way that we saw it.
Want to add anything?
Well, I hesitate to add anything to that. I agree with all of it. David worked for the Senate Judiciary Committee. He worked for the Justice Department in connection with the Microsoft litigation. He has assisted government as well as doing pro bono things in the private sector. I spent 8 years in the Justice Department in a couple of different positions. I encourage the young people in my law firm and the ones that I come in contact with is don't go to one firm and stay there for your whole life. I mean, I have worked for the same firm my whole life, and it's been very gratifying. But I took the opportunity to get involved in legal issues involving politics and presidential elections as did David. That's why we wound up, or how we wound up on opposite sides of Bush versus Gore. We had done some things voluntarily to help out, to be involved in politics, or maybe it's your church, or maybe it's the schools or something like that. But those things are extraordinarily gratifying and unforgettable. And David and I also headed a joint task force on the independent judiciary and support for the judiciary. We went all over the country. This was an ABA commission, some outstanding people involved in it, to try to persuade citizens and legislatures to fund the judiciaries in their states, because you pinch the funding for the courts, you're hurting everybody, and you're hurting the people that need it the most, the people that need help with their rent or their landlord, or a protective order in a domestic relations case. And the funding problem has been enormous in this country. And I guess I'll say this one final thing. As members of the legal profession, we have a responsibility to speak out in support of judges who can't do it themselves. They're not well paid, not as well paid as they should be paid. They are subject to political attacks, and I know what's going on in this part of the country. It's happening in other parts of the country. Individual lawyers and law firms have to be out there and doing it, and if you're not out there and doing it, it's a disservice to the profession that is paying you so well and giving you so many opportunities. So we have got to be out there doing something, saying something, writing something, organizing something, but we have got to do that because it's in our best interest and the best interest of our country to protect the judiciary, who are there pretty much by themselves.
Ladies and gentlemen, these are the stars of the show, and you've picked wonderful recipients. Would you stand and give them a hand?